Isakutampa.
Yes,
30 minutes. 30 minutes.
My lords, we are opposed to this application. And my lords, we rely upon our affidavits in opposition filed on the 21st of February, together with our statement of case. My lords, our first submission is that this application woefully fails to satisfy the conditions for the grant of a review application. As in our view, it does not demonstrate any fundamental error committed by the court which has occasioned the petitioner a miscarriage of justice. And on that ground alone, this application ought to be dismissed summarily. My lords, now on ground A of petitioner's application, the petitioner refers to section 72 of the Evidence Act. Now, my lord, section 72 of the Evidence Act reads thus. 72 sub 1. Subject to the discretion of the court, in a civil action, a party or person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence. At any time, my lords, during the presentation of evidence by the party calling the witness. My lord, it is very significant that in his statement of case, there is a deliberate omission of the controlling word evidence by the party, of evidence. That is, and I see no reason to believe that this was inadvertent, because it is repeated twice. And on both occasions, this critical word is left out of evidence. Now, what is the significance of adding of evidence, reading section 72(1), including of evidence? It means that a party can only exercise that right when he has not closed his case. That's what it means. And I want to repeat this. Section 72, which appears to ground the backbone of this application, relates to a situation where a party has not closed its case. Now, in this instant situation, the party had closed its case. So the court had no business referring to section 72(1), because it was irrelevant to the circumstances of the case. And my lords, it is my submission that knowing that they had closed their case, the petitioner disingenuously omitted of evidence. And with all due respect, this is highly improper. So, my lords, all the submissions around Section 72 that the court was per incuriam of Section 72 are totally unmeritorious and irrelevant. Now, my lords, we proceed to deal with grounds B and C. And my lords, counsel for petitioner has argued that Order 38, Rule 3E, 5, cannot override Section 26 of the Evidence Act, because in his view, the Evidence Act is a substantive legislation, and Order 36 is subsidiary. My lords, 38, sorry, is subsidiary. My lords, it may well be the case that Order 38, Rule 3E, 5, is a subsidiary legislation. But the point here, the critical point here, is that the very principal act, this is the Evidence Act, Section 26, by itself delimits the application of the main text by the words subject to a rule of law or equity. And my lords, there can be absolutely no doubt that Order 38, Rule 35, is part of the laws of Ghana. So it is because of the specific provisions of Section 26 that the court could then look at Order 38, Rule 3E5 and rely upon it in making its ruling. So, my lords, respectfully, I think it is misconceived to suggest that in doing so, the court had committed a fundamental error by allowing a subsidiary legislation to trump a substantive act of Parliament. My lords, we would next address Ground C, which relates to Act 459, Section 58. Ground D. My lords, in our respectful view, Section 58 of Act 459 is completely irrelevant to the matters before the court. Because the matters before this court, which is the subject matter of the review application, relate to the court's decision not to reopen the case. My Lord, that is the decision of the court. Now, Section 58 reads, in any proceedings and at any stage of the proceedings, a court, either on its own motion or on the application of any party, may summon any person to attend to give evidence or to produce any other document. My Lord, this provision presupposes that the party who is applying to summon another has not closed his case. Now, this is obvious common sense. It is very clear that this provision cannot relate to a situation where a party has closed its case. And my Lord, these are the ways in which provisions of the law have been persistently cited out of context. Perhaps to mislead those who do not know the law. So, my Lord, it is our respectful submission that a reference to Section 58 of the Evidence Act, of the Courts Act, in this situation is totally misconceived and should never have been made by counsel. My Lord, we wish also to make the point here, for the last time, that the chair of the first respondent has never made any undertaking that she would mount the witness box, such that the petitioner could claim that he relied on it to his detriment. My lords, all that the chair of the first respondent did was to repeat what the law is. That is all that he did. The law, and if your lordships go to Order 22, Rule Order 22, all that the chair of the first respondent did was to repeat the position of the law, which is that if you fail to obtain interrogatories in relation to a matter, you may, during cross-examination, elicit the same information. That is all. It was never an undertaking. And it beggars belief that the petitioner and counsel are basing that the petitioner and counsel are basing this statement of the law as an affidavit, an admission or a representation that they relied upon to their detriment. My Lord, I therefore wish to submit that a reference to the deposition of the first respondent's chair on this matter can never constitute an estoppel, because she has the right to refuse not to enter the witness box. And the court has ruled definitively on this. This application for review of the decision to reopen cannot be the back door through which that earlier ruling can be considered. The court has ruled on it, and that ruling binds all of us, including counsel for the petitioner. My lords, My Lord, the fair hearing argument, my Lord.
There are 5 minutes more.
Very well. My Lord, I thought I had a lot more minutes. Unless your Lordship thinks I've made out my case. So
You have 5. Out of the 30, you have 5 minutes more.
my Lord, ground E relates to the allegation of breach of his right to fair hearing. My Lord, the right to fair hearing is a right that all parties to a suit are entitled to. So the court has ruled that the respondents have the right to elect not to adduce evidence. That is their right under the law. Therefore, to seek to reopen your case so that you can compel the first respondent through his chair to enter the box is a breach of the first respondent's right to fair hearing also. My Lord, it's our considered view that no evidence or analysis has been made by counsel for petitioner that sustains their claim that their right to fair hearing has been breached. Indeed, this court has been more than accommodating to the first, the petitioner. They defied the court's order with impunity not to file witness statements at the time they were ordered to. They have even again defied the court's order to file closing addresses. And perhaps the court may once again accommodate their defiance of the highest court of this land. And then they turn around to talk about fair hearing. In our respective view, their case should have been struck out when they failed to file their witness statements as ordered by the court. Or it could have been struck out. And as we speak now, since they have defied once more to file their closing address, this case can be settled without their closing address, and it will be fair trial. My Lord, I'm saying it will be fair trial for that to happen. Possibly, the court is once again going to accommodate them. So they should be the last people to be mounting the high horse and talking about breach of their right to fair trial. My Lord, our respectful submission is that this allegation of breach of their right to fair trial is an invitation to the court to go on a frolic which has absolutely nothing to do with the issues before this honorable court as to whether any person, any of the two parties, the petitioner or the second respondent, obtain more than 50% of the valid votes cast in the 2020 elections, presidential elections. My Lord, again, the reference to 296 is in our view quite surprising. Yes, my lords, the court was right in the TDC case to hold that the acts complained of were unreasonable and irrational. But my lords, in the instant application before your lordships, the petitioner has failed once again very badly to demonstrate the facts which ground the allegations of unreasonableness or irrationality. Because those facts, my Lord, are based on the grounds that he has dealt with earlier on, A, B, C, D, which we have demonstrated to be hollow and of no merit. Accordingly, my lords, we believe that, and we submit that the application is devoid of merit. It is deserving of a summary dismissal, and given the fact that the arguments are only a rehash of earlier arguments and the introduction of irrelevant provisions for the consideration of this court, we pray that in this exceptional situation, this application be dismissed as an abuse of process. It be dismissed as an abuse of process and cause punitive costs.
Your time is up.
Malted. And Lord, we are done.
Who's that?
My Lord, may I, with your leave, make a couple of brief references. My learned friend for the second respondent, I heard him a little while ago say that we are acting in breach of the right of the chairperson of the first respondent as far as testifying is concerned, as far as our indication that we are seeking to subpoena is concerned. And my Lord, as a matter of law, respectfully, it is not for the second respondent to bring up a witness's claim to immunity, whether on the basis of a right to fair hearing or self-incrimination or whatever. It is not for the counsel for the second respondent to bring up a witness's claim to immunity. The witness must themselves, that witness must, his or herself, I should say, his or herself, put forward whatever claim she seeks to make to immunity. And my Lord, I believe that that was the reason for our reference to the case concerning the IFC's immunity and so on. And my Lord, counsel for the second respondent also sought to suggest that I had somehow sought to mislead the court in terms of section 72. Well, that's a very serious insinuation. Well, it's not actually an insinuation. It was a very express statement on his part. And my Lord, I can only say that counsel is obviously not clear about the nature of the application that is before you. Because the nature of the application that is before your lordships is to seek to reopen our case for the presentation of evidence. That's the nature of the application that is before you. So reading section 72 about the presentation of evidence and making it seem as if what we are doing is somehow foreclosed because we have closed our case just shows that he hasn't understood why we're in court this morning. Because, my lords, we're in court asking your lordships to reopen our case so that we can go according to certain processes. That's what we're in court for. So for him to be saying that we are trying to mislead you by not referring to during the presentation of our case and so on, my lord, that is just a clear failure to appreciate the terms of section 72. And my lord, he completely does not address the point that we make, that section 72 was not even referred to by your lordships, and that your lordships' ruling is per incurium of that section.
Are you done?
Yes, I'm done.
Yes. I have one question for you.
Yes.
your arguments, you dwell mostly on Section 26. Section 26 of the Evidence Act. Can you show me any conflict between Section 26 and Order 38? Is there any conflict between Section 26 and Order 38, 38, Rule 3, E5? Is there any conflict?
My lords, I was referring to the fact that the ruling implies that there's a conflict, and that in the ruling it says this section is not applicable because of Order 38.3e. And my lords will notice that I in fact went on to argue. I argued that Rule 38.3e5 in fact has nothing to do with Section 26. Your lordship will recall that I argued that. So I was specifically referring to what was in the ruling. The terms of the ruling are clear.
So it was not a matter of the court preferring subsidiary legislation to substantive.
That's what the court said. I mean, I read it. The court said.
No, we didn't say so.
We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38.
But it doesn't mean that the court was preferring or raising Order 38, raising 38 against above Section 26. That is not what we meant.
Well, my lords, I leave that to your lordships, but the language of the ruling is what I'm referring to. But I leave it entirely to your lordships. The language is that it is not applicable in view of something else. So that other thing is being made applicable, whereas Section 26 is not being made applicable. I mean, there's no running away from that. If you say this is not applicable in view of this, then it means that what is you say is applicable.
Yeah. No.
You're setting aside.
That is what I'm not. It doesn't make it superior to Section 26.
Yeah, but my lord, how can your lordship say that Section 26 is not applicable in view of Order 38?
That is our view.
Yes, but my lords, and that was the other point I was going to make, respectfully, and I'm glad that it has come up. Reference has been made to your ruling in respect of another application in which you did seek to consider Section 26. And there we argued that no reference had been made. It was per incuriam Section 26. In that ruling, again, no reference was made to Section 26 at all. In your ruling in that case, your lordship said, effectively, yes, we didn't make reference to that Section 26, but we haven't been shown that a miscarriage of justice has arisen because we didn't make reference to it. And my respectful submission is that, and I did say so, that is itself fundamental error. And your lordship should take the opportunity to correct that error, because you didn't make reference to Section 26, and you sought to justify that by saying that no miscarriage of justice has been shown to you. And my submission was that when you don't apply a statute, there is no reason for miscarriage of justice to be a further ground.
Different from,
I'm sorry.
When you don't make a reference, it's different from not applying.
Well, my lord, if you don't even make a reference, you can't apply. I mean, if you don't even make a reference to it, you can't apply it. I mean, you make a reference to Black's Law Dictionary. Black's Law Dictionary, you make a reference to that. Black's Law Dictionary is not binding on this court. It's stating common law rules which have been changed by statute in this court. But you make reference to Black's Law Dictionary. But you don't make reference to the statute that is binding on you. Well, that is per incuriam. That's
no. That is your opinion.
Well, that is indeed my opinion, and I think it's backed by a plethora of authorities of this court.
The court will rise to consider his rule.